Hi guys, it's Kathy. I hope you're doing well. I tried to fix this delay, this slight delay. I can't, it's just there. But at least the camera works, and hopefully you can hear me. And hopefully when I press play on the video, you can hear the video. I'm not making any promises. Look, if you want professional, go to Bill's stream. Here you get half awake YouTube. Things might work. Things probably won't work. But that's fine. So today we're just going to stick in one courtroom. It's in Colorado. It's Judge Blanco again. And it's the mental health docket. So remember, this docket, I almost don't want to say it like this again. It's not about punishment. It's about recovery. So her whole job is to, first, number one, get them to take their meds. That's her number one job. Number two, it's about getting them mentally stable to go back to trial. So it really doesn't have a lot to do with their crimes right now, except it does. So like, she knows exactly what crime you did or are alleged to have done. And I hope we get to it. I don't really know if we're going to. She watches one of the crimes on a video. Thank goodness she doesn't play it for all of us because she can't get through the whole video. But mental health docket. Let's see if any of them are close to being restored in Colorado.
I'd like to call the in custody matter first, if you don't mind, just so I can keep the docket flowing, and then I promise I'll call her next. Okay, thank you so much. Just so we can keep things moving, Kent Brown, 25M1004, 25M333 is present before the court. He's in custody. Ms. Lowry is present as counsel. We in need of an evaluation.
I'm hoping not, but Mr. Axbacher was going to take a look at the case. Mr. Brown has been in custody for about 60 days. Believes these cases were already dismissed.
Yes, I was in court here. I dismissed two cases.
But they haven't.
The harassment and the knife case introduction.
Yeah.
They were both set and I did trial and we were dismissed. They were dismissed. I shouldn't have any cases.
I don't think I've ever met you before.
No, it was a male. It was a male judge. I should have both cases. They were dismissed. Both cases were dismissed.
Okay, I don't know anything about that.
Plans to go to Wyoming though, so I didn't know if the. Anyway.
Yeah, but I'm not incompetent. I mean, that lady, she tried to with me last time when I got a new lawyer and I didn't. She just.
I'm not incompetent.
He dismissed both cases, her case and his case. And I just got through with those and she said I had to go to Loveland to another court case to get the bond drawn.
Okay, sir, just a minute. I understand that you are wanting to communicate and you're the one who's, I get it. Hang on a second. Let me see what's going on for a moment. I don't show that these cases have been litigated. There's nothing indicating that there's been a trial on these matters. In fact, one of them is from March 18th.
This is the one that was in here for the town.
And then the other one is, hang on. The other one is from, it looks like May the 5th. So I don't show any record. These are fairly new. So these must be newer cases. Mr. Oxbacher, do you feel like you need an evaluation, sir?
Your Honor, I am going to request an evaluation. Mr. Brown was in the competency process back in 2017. He was initially found to be incompetent, but was successfully restored. Since that time, he has had multiple cases in the court system where competency was not raised and where he entered pleas. I can tell the court that the 25M333 case is currently charged as harassment as a class 2 misdemeanor. However, I'm looking at the facts and there's a possibility that it could be amended to a menacing class 1 misdemeanor. I'm still evaluating that.
Okay.
So my request here today is for an evaluation.
Okay, I'm gonna appoint Bridges. I'm going to order the evaluation. Mr. Brown, I don't know if you heard what I just explained, so I'm going to explain it again. The evaluation is for me to understand how much you're able to defend yourself against the accusations of the government. And so they're going to come and interview you and they'll produce a report. It's a doctor, but it's not like a private medical appointment. They're gonna write a report. If you want to talk to Ms. Lowry before they come meet with you, that's totally fine. Let's get this hurdle cleared so that we can move your case
So I
along.
That was my question too, Your Honor. Would the
Yeah,
court be
I've
willing
already
to
done 2
modify?
months, this is holding up my life because the guy that put the harassment charges wasn't even involved with the doorbell because of my leg. I was there for a totally
Yes.
different reason.
This is not PRA prosecution
As charged as harassment, it is not a VRA case.
and
There's a PR bond on the 25M1004, but in 25M333, it's $300 cash. He's not able to post that.
he failed to appear in front of Judge Acton, it looks like, on
That's what I was
April,
supposed to appear for. And then I didn't make it because I'm on the streets, you know, and
in front of Judge
I
Acton,
didn't
it
make it.
looks
They
like.
arrested me for the same charge.
I really am trying to treat you with respect. Please stop interrupting me. I promise I'm listening to you. I'm just trying to figure out what happened. So on April 1st, there was a failure to appear. And I think that's how the bond got reset at 300 cash. On May 5th, however, it looks like Magistrate Lemus set him a PR bond in the newest case, which is the class 2 misdemeanor, which I think you were explaining had something to do with an accusation about a tablet. Ms. Lowry, what is the request?
So I'm asking the court to consider modifying the bond in the M2 harassment case as currently is charged 25M333 to a personal recognizance bond. As I mentioned, he's been in jail for 58 days on this class 2 misdemeanor. I understand the DA may be reevaluating, but I'm wondering if the court would be willing to allow him to do the evaluation on an outpatient basis.
Okay, let me look at his bond application, one moment. Well, I'm looking, and this also has 20 failures to appear. If I'm reading this.
20 failures to appear. 20.
Prosecution.
Yeah, Mr. Brown originally had a PR bond in 25M333 and resulted in a cash bond for the failure to appear. I will defer to the court.
No, I don't run, you know, I mean, I'm not hiding. I'm always in town, so.
You know, it's not whether you're in town or not. You need to be in court when the court case is scheduled. If
I'm sorry, but I beat those cases in trial, and then all of a sudden they keep throwing more stuff up.
my friend, these are brand new
I'm
cases.
in here. Inside the jail.
Okay, but you haven't had trial yet, and these haven't been
Inside the
dismissed.
jail.
Right, so you have 2 new charges and we have to take care of them. And even if you're in the community and having transportation issues, if you don't show up to court, you get a warrant. And it's 20 times over that's,
Late.
okay,
I was dealing with the money, and that's where the harassment came from on my brother. I'm being there because it keeps playing with my money. Yeah, I'm having a hard time struggling with my broken leg. I gotta walk to his house. And every time I go there, he never has my money. And he's the one that took it to the court and won the thing, but he spent my money on his bills because that's just what he did. So I'm just trying to live on his $200 a week. And he doesn't have it every week. So I yelled at him and I was yelling at him and
okay.
I was walking away.
I'm just going to state, I've ordered the evaluation. I am not going to modify the bond today. I will revisit it when we come back to court. And I cannot overlook Judge Acton's warrant. And I'm going to reset this. Give me one moment. It's gonna be a little while before we get the evaluation slide.
All right. While she's thinking about and doing that paperwork, a big shout out to New York City. Over the last month, you are my #1 viewers, followed up by Los Angeles. Thank you, LA. And I don't think it's because of the OJ trial either. And also Chicago. Oh, I love your pizza. Oh, New York, I love your pizza. Oh boy, LA, I love your sprout wraps with quinoa. When I think of LA, I think everybody's eating, lettuce and kale, a lot of kale. I bet a lot of kale is sold in California. Anyway, thank you so much, guys. Top 3. Appreciate it.
July 31st at 2. If you get it back sooner, we can bring him back earlier. These are not VRA cases.
So it's another month.
Potentially. Now, if you are not competent to proceed, these cases are eligible for dismissal.
Let's
If you-
get another child.
Hang on a second. If you are competent to proceed, sounds like you've been in custody for a long time, Ms. Lowry might be able to negotiate something. So either way, let me set it for a disposition or potential bond review when we come back. And if you can come back sooner, Ms. Lowry will let us know. As soon as we get the evaluation, we'll bring you back earlier. Okay?
But that means July 31st.
Yeah.
No later than.
It's just on this town, in jail.
And the harassment.
And the guy that was even involved in the harassment. That he just called the police because I was yelling at my brother and he didn't do nothing, but this dude just messed my life up because he has a cell phone. Write that date on it, right?
I did. July 31st.
Okay, another month just for some new.
There's my number if you need me.
Alyssa Montoya, 25M5056, 25M362.
Nan, I gave him your number too in case he needs you. That guy.
Is present before the court out of custody, present with her counsel, Ms. Lowry. Hi, Ms. Montoya. Thanks for your patience. I like your top. Yes, yes. And so I just need to check in. You're doing really very well on pretrial, which is great. Just make sure you don't miss any check-ins, but it seems overall you're doing a good job. And I just want
Yay,
to
good job.
evaluation in this matter as well. So one moment.
Your Honor, this is a case where Mr. Axmonger indicated he would do a 1355 referral. So we are asking the court to approve Bridges today. That's not, we're not quite there for the intakes, but they could meet with her in the meantime. And
I'll point Bridges, and we're going to reset you to the end of July because you're doing well. And so let's have you back on July the 31st at 3:30. Will that work for you? All right, July 31st at 3:30. And then Bridges is just a group of people that help support folks in the criminal justice system, and they have ability to help connect you with some resources and be a good support for you. So I don't think you've met anyone from there yet, but there's some folks here in the courtroom from that program.
I briefly spoke with them.
Oh, good.
Too much, but I had to end.
Oh, good. Okay, wonderful. They're great. I think you will enjoy working with them, and then I'll see you back on July 31st. Ms. Lowry, anything else?
no, I don't think so.
All right, thank you. Deputy behind the Boulder County Jail, I see that you have Mr. Greger there. Let me call the Joshua Greger matter, and then I'll get the other mobile unit there. Boulder County Jail, 24 CR 494, Joshua Greger's matter, and I'm going to unmute you, Mr. Greger. Okay, you're unmuted now. Ms. Lowry's
Bill,
in the courtroom.
Bill, hey, Bill, your brother's on the screen. Let's look and see what happened to Bill's brother.
As your attorney, I know you've been waiting a long time for movement to the state. You're doing a good job inside of the Boulder County Jail, though I'm sure this is hard. You've been in the jail for a very long time waiting, and I just encourage you to hang in there. I mean, I know the Boulder County case is far more serious than what we have here in Larimer County, but it has been an awfully long time since the referral went in for you. Ms. Lowry?
Yes, it's good to see you, Josh. It's unfortunate. I heard that he's been waiting the second longest of anybody to get down to the state hospital, but the court's right. It's really the Boulder cases, I think, that are prohibiting or limiting the facilities that he can go to. So hopefully he'll be
Do you
on
know
his way
number?
soon.
What number am I on the list?
I think I saw 54th.
Today?
That was the last update I saw, which I think was at the end of last month, actually. So it's a few weeks. ago.
Is there any way you can check really quick on the computer? Because I can't get a hold of my other attorney.
We don't have access. They write a
She's got
report.
access. She has a list.
No. They filed a report about a month ago, and that's where you were, but it changes every day. It depends on how many more people are referred and where you are, how many people are more acute,
Right.
meaning they're more in need of mental health help than you. So that list changes all the time, but maybe I know that you work with Anna, and maybe we can try to
I
get an
haven't talked to
updated.
Anna for a long time.
Okay.
For
Maybe
about a
maybe
year, I haven't talked to her.
maybe
I haven't talked to Anna in a long time, like one whole stream, but that's okay. Anna left a comment, so I know Anna's okay.
we can get an update, Ms. Lowry, and send it to him. Are you able to maybe help get that number?
Yeah, when I get that next report from the hospital that says what list you're on, I can send that to a copy of that to you to the jail, Josh. And if I hear anything sooner than that, sir, I'll definitely get that to you.
The last time you checked I was 54th on the list.
On the report that they filed on May 27th, you were 54th on the list.
On May 27th, okay. All right,
But
that sounds pretty accurate probably then. 57th on the list or 54th on the list?
54th,
Okay.
5-4.
Anna, is there something you wanted to say? Anna wants to know if there's a good phone number she could reach you on in the Boulder jail.
Your Honor, our facility doesn't allow that in our system.
Peekaboo.
They have access to collect calls that they can make. That's about it, other than writing. Yeah.
Okay, thanks.
If Anna's in the court, I got those 2 pictures that you sent me. But there was 3 more of them with it and they didn't come. So I didn't know if you still had those or access to those. But I was hoping you maybe send those if you had them still.
The only pictures that I could find in your bag, Josh, were those 2 pictures, so I'm not sure where those others went, unfortunately.
Okay. Well, I
Yes.
really appreciate you sending those. That was definitely a godsend. So.
Yeah, absolutely, and I'm sorry I haven't been able to contact you in so long, but I'm still here and still rooting for you from down here in Larimer County.
All right. Thank you.
You're welcome.
August 21st, 2 o'clock.
Hi, Terry.
Will be our review date. And Mr. Greger, know that that list constantly changes. So you could be 54, then you could be 20. You also could be 54 and then be 70, because it constantly changes depending on how many people all over the state of Colorado in courts are being referred. So just, why do I say that? Because I don't want you to think it's so easy as you're 54, then you're 53, then you're 52. It just every day fluctuates, but Ms. Lowry will send you what she has the next time she gets the update. Okay.
All right. I wanted to say, take note, the Star David right here. And then I have my cross, the crown on it, and John 3:16 right there. So he sent his only begotten son so I could have eternal life, and so could everybody else, as long as they believe in the Son. So that's John 3:16 right there.
I can see that. Okay.
Uh,
All right. Let me make sure prosecution, you can do a writ from Boulder County, August 21st at 2. I'm glad that you are getting connected with spirituality. It seems like that maybe is also helpful in the circumstances you're in for you. So I like that. Hang in there.
Thank you.
Thank you, Mr. Greger.
It's good to see you.
Guy's been waiting the second longest in Colorado to get an evaluation, which could be worse. He could be in any other state. Bobby, I was thinking the same thing. Colorado is really good with they're getting really, really, really good with their mental health. Better than any of the states that I can see through courts. I can't see everything through courts. You know, we only see what we see. But from what I see, Colorado is really doing a good job.
Your
Yes.
just an FYI, I emailed your clerk. It appears he has an additional case in Larimer, but it's still been floating around. It is 24M1497. I think it gets missed because his last name has 2 G's in that case, but everything else matches. I want to make sure the court's aware.
Could you give me the case number again, sir?
Oh, certainly, Your Honor. It is 24M1497.
Hang on one moment. Is that a misdemeanor?
Yes, Your Honor.
M2? Okay. Let me see if it's eligible for dismissal to clean that up. One moment.
The charges are an M1 and an M2. Looks like there's an active warrant, but I would have no basis to object if defense moved to.
I'm going to call 24M1497, appoint Ms. Lowry in that matter to represent you. And it sounds like you have a drug misdemeanor 1 and a class 2 misdemeanor. Can I adopt the findings into that case? Court's going to find that you're not able to aid in your own defense adequately, and based on that, you're eligible for both of those charges to be dismissed. And so we'll make sure we process that case is being dismissed and that warrant won't be hanging out there. Glad the deputy brought that to our attention.
Appreciate that.
Okay, sir.
File a proposed order.
Okay, I will sign the order when it comes through. Thank you, deputy, and thank you, Mr. Greger.
No problem, Your Honor.
Thank you, man.
You too.
The guy in the courtroom is making me nervous, just so you know.
Before I get to mobile 1, I'm so sorry. I do have someone in the courtroom, mobile 1. Hang tight. This person's from the 1:30 docket. And I'm going to call the matter of Mr. Haya. Also on our docket is Mr. Richard Ertl, 21T926-18T3046, 21CR451. He's present before the court. He's in custody.
Before we get to this, I got an update. I got news, guys. All right, you know how we watched Judge Eric Johnson? Well, the defense attorney, and I'm 50% sure I'm right. Could be the prosecutor, but I think it's the defense attorney. Mr. Sunshine, he's getting married this month. I'm pretty sure it's this month. It could be July or September. He's getting married sometime real soon. Isn't that exciting for him? So now there will be a Mrs. Sunshine if she takes his name. But I thought that was exciting. I thought you guys would want to know.
Lowry is here as counsel. All right, we had a failure to appear quite some time ago, but restoration was kind of an issue by July of last year. My warrant went out on September 26 last year because of failure to appear for court, and the CDH has completely closed in November of last year as a result of all of this. I'm going to, if there's no objection, dismiss 18T3046, whereby I believe maybe that is eligible for dismissal.
I think it's also another case, the 21T926. They were charged as, they're older, but charged today. They would be driving under suspensions, eligible for dismissal, and Mr. Axnocker didn't oppose dismissing those 2 cases anyway.
That is correct.
Okay, then I will dismiss those 2 cases. And they are not eligible for seal. And so that leaves me needing to set a bond in the 21CR451 case.
Damn it. Now I want to play Sims. Now for the next week, all I'm going to be thinking about is playing Sims. And I won't play Sims because I want to make sure I keep doing my YouTube videos. And if I start playing Sims, you'll never see me again.
Prosecution?
The prior bond in that case was a $1,500 cash bond. I'll note that it got to that point based on several FTAs. Mr. Ertl FTA'd in this case and has not reappeared for the last year. So I do believe a significant cash bond is appropriate. I would ask for $2,000.
Ms. Lowry?
Yeah, I'm asking the court to do a considerably lower bond than that, just in light of the charges. This is a 21 CR case. It was the basic allegation is driving while his license was suspended, but he did identify himself to law enforcement as Richard Haya. and had some kind of document that purported to be something from the DMV, which he told them that he had written himself. That is the charges. He has served time on that case in March of 21, April of 21, April of 23, February of 24, and now he's been in custody on this warrant since May 23rd. So all told, he served 35 days. I understand the failure to appear.
Okay, yeah, okay. I'm giving it to the defense on this one. Driving while license is suspended. He's already been in jail for 35 days when we've seen people pay a fine. So, yeah, he has failures to appear. Yes, he does. But he's done a month for it.
Issue. I also know that, when I look back at Dr. Ort's most recent report on June 4th, she indicated that, this is not an individual that's going to meet criteria for court-ordered medication, but not likely much progress is going to be made on this case with Mr. Ertl's complex belief system, which preclude, in her opinion, his demonstration of competence. I just don't think that a $2,000 bond for driving under suspension and using a name that we've continued to address him through many years of court proceedings here is appropriate. I'd ask the court to consider looking at the original bond in the case in light of the fact that now he's been in jail longer on this case than he ever has in the entire time of this matter since May 23rd. So I believe he will return to court. And I would ask the court to consider a $250 cash bond.
I am not persuaded that he will return to court. The reason that the bond keeps increasing, it's not because of necessarily what he's charged with. That's where the initial bond was set. The bond is supposed to assure the court that this person will show up for court and won't pick up new charges, and he does not show up for court. He does sometimes, but in the history of this case, since March of 21, to your point, I count at least 4 times that bond has been set because he does not come to court when he is supposed to, the most recent being almost 1 year since he's been engaged in restoration. And in September, it'll be the 1-year anniversary since I've seen him. So, well, that was the failure to appear. It might be close to 1 year since I've seen him. I'm going to set the matter in for a $2,000 cash only bond with the same terms and conditions that were previously in place. I am understanding what you're saying though, Ms. Lowry. I mean, I don't know if there's an alternative way to resolve all of this, but I'm really not interested in Mr. Ertl at this time putting me on a goose chase again. He is going to be ordered to inpatient restoration. And I'm happy to reset this.
A goose chase sounds fun though, doesn't it? I think it sounds fun. I'm in. Let's go.
Come back to see if there's a plan or if there is an agreement or whatever may be determined.
Could you give me one moment? I just want to see, are you going to be able to make that bond?
Well, he's going to be on an inpatient order.
I need it greatly reduced. I thought you were going to do a motion to dismiss them.
Well, he said no, so 2,000 cash he cannot make. He cannot, yeah, it doesn't sound like he can make.
Well, she said no.
And on an inpatient restoration basis anyhow, and I don't know when it's advisable for us to come back. I can come back on July 10th at 3:30 to see if there's a plan that can be put.
Will it work to grease up goose like you do pigs? You know, when you have a pig chase, but they grease the pig first, so you can't. Can you do that to geese? I bet that would just be, well, no, you could just use Dawn. You could just use Dawn to get it out of their feathers at the end. It's fine. I've seen it. I've seen Dawn get oil out so they can get grease out.
Put in place.
And Your Honor, I don't know, the last evaluation was June 4th of last year. I know that the comp team brought up I'm not suggesting that I think that there's been any change in the ultimate opinion, but I did wonder if the issue of restorability.
No, Kelly.
Appropriate for an evaluator.
It's more than one is shenanigoosin. It's goosin, not geese. Come on. Anybody know where that's from? Moosin? Forget it.
prepared to look at that issue.
I'll let you speak with Isaac to see if they'll send someone out there and again, I understand what you're saying. There are the charges and how they're stemming. I know that you do a great job, and so does Mr. Oxmacher, of discussing where we're going with this matter, how long he's been in the system, what our goal is in general at this point. And so I'll revisit all of this on July 10th. People are noticed that
May I say something?
not yet.
Okay.
You've been missing for almost 1 year, so just a moment, please. July 10th, when we come back to court, I will address bond at that time. What would you like to say?
We spoke earlier and I asked you, why am I being held surety for this deceased person's charges? And you said I'm not being held as surety for this deceased person charges. So I don't know exactly what's going on here. They have the paperwork, you have the paperwork that Richard Earl.
Your paperwork, quite frankly, looks like it's forged. I'm glad that you don't have new charges for trying to influence a public servant. And so let's be grateful that you don't have new charges. These are the charges. Your attorney can help you talk about why you're here, but this is the order of the court. I will see you on July 10th. Thank you. Deputy, who do you have behind mobile unit 1, please?
Oh, mobile unit 1, you're in trouble because she's annoyed now.
Court calls Eric Melcar's matters 25 CR 46, 24 CR 5272, 25 M70. He's present before the court in custody, appearing virtually from our jail. Mr. Melcar, it's important for me to tell you that Ms. Lowry is in the courtroom as your lawyer. And we had you on our docket, Judge, I believe this case is from maybe Judge Gerard. Is that accurate, Mr. Oxmacher?
She does McDonald.
Judge McDonald. I do know that the speedy trial has told, but I do know when things are pending a trial, they typically are not supposed to come to us. One potential solution is
You
this
wish.
court, if there's a finding of competence, is not the court that enters it and sends it directly to Judge McDonald to be the one who enters it so he can manage the speedy trial issue. The other option is to send it back. And so I know that this was not originally supposed to come our direction. Judge McDonald felt his team might be in the best place to help him so that they might be able to resume their trial. So thoughts, I know, can I dismiss Mr. Oxmacher 25 M70, the petty offense?
You may.
Okay, I'm going to adopt, well, I guess I don't have an evaluation yet.
There is an evaluation that he's not competent. I would ask.
I see.
I should file a motion to dismiss.
I see. Okay, I will dismiss 25 M70 and Mr. Oxmacher.
Thank you, Your Honor. My request is to send this back to 4B. Just this morning, I was dealing with another case that was similarly situated that came into our courtroom, and we are dealing with speedy trial issues.
Okay.
I want this team to be effective, but there's a reason that our MRU says the case is pending trial. Should not be here, so that's my request.
Okay, let me get you a new date.
Hold on, wait, what? That doesn't make sense. I don't understand what's going on. They're sending it back to 4B. Did they find him competent? He's, because of the way he is attending court today, makes me feel he's not competent yet, right? So why would they send it back to 4B? That, I don't understand. I must have missed something while I was watching chat.
I think, I'm not sure that the judges all realize that that may be one of the caveats. Maybe the attorneys being aware of it could also help.
Yes, sure. We actually did a training yesterday for all the DAs, and we discussed this at length.
Thank you.
And Mr. Melcar is eager to have the court review his bond. Would it be possible to set it in 4B for a review of bond? I think Isaac went to speak with him yesterday, and my hope is that.
Just one second.
Your Honor, if I may, I need to speak with my attorney for a moment. There was an event that occurred yesterday that my attorney needs to be made aware of.
Okay, I'm gonna have your attorney contact you, but
Dun,
right now,
dun, dun.
unfortunately, is not something we can address because I need her in the courtroom. She represents quite a few people on our docket, so give me one moment, sir, and she's aware. She will make sure you are contacted. She's writing it down. One moment.
Yes, ma'am. Thank you.
I love you, security. I do, I do.
And Eric, while the judges are looking up that date, I'm in court for the rest of the day, but I promise I'll give you a call tomorrow, okay?
Not a problem. Thank you.
Okay.
I guess it's not getting sent back to 4B once that new case hits, huh? Security, thank you. I appreciate that.
We're not getting a response, so we're just trying to pick a date on the calendar. Just a moment.
Hey, you got Salty
The
Rider.
morning of July 3rd, Ms. Lowry? At July 3rd at 11:30. And we will put a note in there that the defense would like to address bond people you're on notice. And I'll let Judge McDonald pick it up from there. Okay? All right, thank you.
She does have one, easy for you guys to say. DJ, she does have someone cuss her out today. And she kicks him out of the courtroom. I don't know if we're going to get to that today or tomorrow. I'm going to show this whole docket. CJ, I sent this with my daughter into her job interview today for me. It was earlier today for me, okay? And she nailed that job interview. Now, I don't know if she got the job because they're still interviewing. They still have 3 more people they said they have to interview. But she did great. So we went to the casino. She came to go to the casino on Wednesday after work. And the casino is like 45 minutes away. So it's a 45-minute drive there, a 45-minute drive back. And that whole time, I am just pelting her with professional interview questions to prepare her for because this is her first real live interview. Like, she worked at Burger King, that didn't count. She works at Big Dog with me, that certainly doesn't count. She had a job at Millersville University, but she was a student, and she worked at help desk, which they were just dying for people to answer the phones. And her mom also worked in the IT department, so that interview really didn't count. This was her first one, so we were, tell me about your weaknesses. And all of her weaknesses were really her strengths, don't worry. It was fun. It was fun. I haven't had to worry about this in a while, but I'm like, listen, I said, if you're in your job interview and you get nervous and you get stuck on a question, just think about what's inside your purse and it'll help you refocus. I don't know if she did or didn't. I just know that she nailed the interview. So I blame you. Thank you, CJ.
Vacate bridges on that, since we're sending that back, please.
And we'll vacate bridges at this time off of that matter. Thank you for reminding me. And then let me, I am going to call Derek Nolan's matter, please. 25 Sierra 513. Do I have Mr. Nolan here?
Yes.
Right. He's present
Man, we had a
for
baby
using
together.
custody.
Thank you,
Mr.
man.
Penning is present.
10 months. That's a
And thank you
baby.
for accepting the appointment on this case since the public defender's office had a conflict. And Mr. Nolan, I don't know you very well, but I know that you have experienced a huge loss while you've been in jail, and I'm really sorry that you're going through that. Really, my heart breaks for you that you've gone through that, and you are still behaving properly in the jail. You're taking the medicine the way that you have worked out with Dr. Ziegler. There's no doubt that what you've experienced, it is grief and,
Dr. Ziegler. I wonder if it's even at all possible his first name is Zig. Remember Zig Ziglar? I just showed him on my stream just a little bit, just a couple days ago.
I know that you're trying to work through those things, and so hang in there. And Mr. Cunning will now be taking over your case to help you. I don't think we've had an evaluator assigned yet. I'm gonna ask Isaac if we have an update regarding that.
Isaac, I can't hear you.
I don't know, your internet is kind of choppy. I don't know if you want to just put it in chat. I'd be happy just to kind of read it in there.
Isaac and I share the same internet connection.
And I think he said no, but I'm not sure how far out to set it, Isaac, if you have a recommendation of when we might be getting the eval back.
Okay, I hope today's a good day.
Mr. Crenning, your client, he's been taking medication pretty consistently, and even the mental health watch dropped on June 6th. I don't know, maybe when you interact with him, you may not feel like it's necessary any longer. I don't know to have the evaluation, but you just got appointed, so you're gonna need a little bit of time.
Well, based on what I am able to discern, primarily from the affidavit and the facts leading to his arrest, I think that the evaluation should proceed.
Okay, it's ordered.
It is, yeah, right. We're just waiting for it at this point. My understanding is today, this was coming back to talk again about bond.
Let's sure. Happy Bonnaroo weekend. I don't know what that is, but I'm going to have no, I'm not going to have a happy weekend. I work all weekend. I'm going to have a happy Monday. Thank you, though. Thank you. Thank you. I appreciate that. I hope Bonnaroo isn't like you too, right? It's not. I don't like you too. I love all music, but that group, I have to stretch myself to like.
It looks like it was addressed within the last 2 weeks, the last time he was here.
Let me see.
I think there's been a notable change in his life circumstances you touched
Let
upon.
me just see here. Well, actually, last time he was with Judge McDonald. I think this is actually the first time I've met Mr. Nolan. And he did have representation at that time. And it was noted that Judge McDonald set it for me to potentially review bond today and ask that the DA be VRA compliant. And it looks like the current bond is $500 cash. And I don't know if we are VRA compliant to address bond today.
We did reach out to the victim and get some feedback, Your Honor. I'm not sure. The victim maybe was going to be present. It's Mr. Wilbert.
Do I have Mr. Wilbert in? Doesn't look like anybody that in the.
Hello,
courtroom
Wilbert.
matches that description, and no one's answering the call of the court in the courtroom. Mr. Oxmacher?
Mr. Wilbert is opposed to any modification of bond in this case. I'm not sure if the court has read the affidavit.
I'm making my way to it. I'm reading the bond application. One moment.
Oh, the Navy. Okay, that's awesome. Oops, it's frozen. No, it's not. She's pondering, guys. Judges need to ponder.
Okay, I have reviewed the affidavit.
Thank you, Honor. The original bond commissioner recommendation was for cash, 1,250. I believe bond was only set at $500, recognizing the mental health component of this case, but also taking in mind the fact that he was on bond for 3 matters when this case was picked up and was being supervised by pretrial in Rio Blanco and in Garfield County, and also on probation in Weld. Given the victim objection and the fact that I think that the mental health aspects of this were already taken into account, I'd ask the court not to modify bond.
Mr. Cunning?
Well, when you read the affidavit, you don't have to stretch to see that at the time Mr. Nolan was operating in a different realm. He has been taking medication now and seems to be back to us,
Pontificate.
if you will. This isn't a terribly egregious case of burglary. It's charged as an F3, but of course that has primarily to do with the fact that someone claims that was a residence. He's got 2 other bonds that are not going to be touched. One's in Morgan County and the other is in Weld County, I believe. So regardless of whether we do anything with this bond or not, he has to face those 2 over there. What I'm asking you,
Sir, excuse me, sir, but burglary is not a nothing felony, People who are burglarized suffer. They just do, and they don't just suffer because they lost something they paid for with money. That's not why they suffer. For the rest of their lives, they're going to be worried now that it's something that whatever they have is just going to be taken from them at any time. So people who burglarize things, it's not a nothing. It's not just, it's just an F3, but it wasn't a residence, though they say it was. Doesn't matter.
court to do is to convert this to a $500 PR bond or make it a co-signed PR bond. I think his mother would be the co-signer. And that gives her some ownership in this. And then let Morgan and Weld do what Morgan and Weld does, which is probably nothing for the relief of Mr. Nolan, but at least he has an opportunity to bond out here while we await an evaluation. I suspect the evaluation is going to come back competent now because of the medication, but at least we'll have an opinion that medication is going to be an ongoing challenge and issue for Mr. Nolan and us to deal with as we fumble through this case.
I don't see an update from Isaac in the chat. I'm going to decline modification of the bond at this time. I'm having a hard time understanding, other than the medication, which is being provided in the jail, which is providing stability.
Yeah, what Chinny said.
He was on his own. There is a lot of stability issues that are highlighted in the bond application. There's not a real sufficient plan for the court to feel comfortable modifying this to personal recognizance bond. At this time, maybe a plan can be developed. I'm happy to remain open-minded to it, and Kenny will be working with him as well. And we will potentially revisit that bond when we come back, but I would like to have that evaluation, Mr. Cunning, completed.
Right.
Now, I will say this, he might be a great candidate, for example, to be screened for the work release program that we have through competency, but you'd have to figure out how to clean up those 2 other holds.
Mm-hmm.
And I'm not sure how easy that is or isn't. Court will set this matter in for July the 31st. Are you able to accept that date, Mr. Cunning? I also have August 7th available.
I'll take the August date, Judge. I'm sorry.
No, you're in a federal trial. I understand. August 7th, we'll set this in at 1:30. Kenny, if you could please look into the potential of the work release program, and then Mr. Cunning, maybe you can see if there's some magic to be worked if he's accepted into work release. We will readdress bond when we come back on the August 7th date. If this evaluation comes back sooner than that, please let me know for VRA compliant. I'd bring him back sooner and address all of it sooner, as long as we're VRA client.
And as I understand, the evaluation's been ordered, but
Yes.
we haven't got it. It's a work in progress.
It's a work in progress, and I'm hearing that they're coming back at the very end of July.
That's unfortunate. That is unfortunate. I know that I fix it. My cat. I know that I fix it. I just don't know off the top of my head how much longer it goes on for. And it's unfortunate.
Which is why I was gonna bring it back on the 31st. And I tried to find out, but I haven't seen anything come into the chat from Isaac.
All right, I'll try to get it.
Just wait a second, we might have a direct message.
I've never played that I know of.
First or second week of July. That is actually very helpful. Give me 1 second, let me adjust the date.
Okay.
You said you are here on the 3rd of July, Mr. Crenning, or you're not?
Not, but I am with you on the 10th.
10th, okay. Let's set this in on July 10th and we'll set it in at 3:30. People are on notice, we may be addressing bond at that time. We'll see you on. the
Or I
2nd
could
of
just
July.
stop
You're
doing
welcome.
things that are unfortunate.
Yes.
I could just
And,
be better.
let's call Christopher Philback for a moment, 19 CR 1026, 18 CR 2465. Mr. Sims is present in our virtual.
That must be
courtroom as
frustrating.
counsel. For Mr. Philback, who's appearing out of custody in the virtual courtroom. And Mr. Philback, how are you?
I'm good. How are you?
Doing pretty
Okay,
good.
we can see him.
Sounds like you're doing pretty well from everything that I'm hearing. And you have a reevaluation coming up soon on the 18th at noon. Do you need to just connect with Lauren? So that you can make sure you're in the right spot to do that eval, okay?
Yeah, I talked to her earlier today.
Okay, that's perfect. And so that's next Wednesday. And I'm hoping that we get really good feedback from that because I know you've been working really hard and you've attended almost all your restoration. So well done. Mr. Sims, anything else?
No, Judge. I was just going to ask for the court to set it for a review after that evaluation comes in.
Okay, prosecution, anything further?
No, yeah.
Mr. Sims, I have a docket on July 3rd. I could set this in at 3 o'clock or later.
Judge, I'm out the first 2 weeks in July. I'm available on July 17th. I
We're
have
actually
nothing on
not,
that day.
we're not in session.
Or
that
the
day. We do
Hawk.
have
Okay.
coverage on July 24th in the afternoon.
Is there anything in the morning? I did have temporary orders on another case that afternoon.
Unfortunately, this docket is only in the afternoon.
Okay. Well, if we could do it like at 4, I think I might be out of the hearing.
Okay. July 24th at 4.
Please, he needs to keep his eyes on the road. Judge, end this hearing.
O'clock. We'll set this in for potential disposition and review. And Mr. Philbeck, just stay in contact with Lauren. Don't miss that appointment. They don't come around very often and that might help you get unstuck, okay?
Okay.
All right. Thank you, Mr. Philbeck. You take good care, sir.
Thank you.
You're welcome.
Thank you, Judge.
No problem. Court will call Josiah Wales matter 25 M5112, 25 M52.
I'm just going to see real quick how much longer. We might skip Josiah Wales because, all right, we are at 127:43. Okay, it's not that bad. That's 20 minutes from now. Oh, that's 10 minutes from now. So, listen, it's just for a few more minutes, guys. Damn cats.
Mr. Crenning. Nice to see you, Mr. Wales. Got your evaluation back. Let me see if there's any objection to it, Mr. Crenning.
Based on my interaction, I don't have any objection, no.
Court is going to adopt the finding that you are competent to proceed. You can help defend yourself against these accusations. Mr. Crenning, I show these.
You know what's really frustrating about this? The laptop that I used for this one is an older, crappy laptop. I mean, so it has and I don't know why. It has a touchpad, like a normal laptop, and below it, the right and left mouse buttons on the touchpad. And then above the touchpad are another right and left mouse buttons. And like you can't, when you on a normal laptop, you could just like double tap the touchpad to hit enter or click something or whatever. No. You can't do that on this laptop. You have to click the top mouse click, which is very unfortunate. It's very frustrating to work with. So the cat would have actually had to have the mouse pointer on the side of the screen where it moved it up and click that button, which would take me considerable effort to do. Like I would have to scroll over with this finger, click with this finger, and the cat. It's almost over, guys.
Matters all came from Judge Lehman in Division 5D.
Correct.
Did you clear a date for this case too?
I think so.
Maybe. We were told we can use the August 11th date for
Yes.
you
Okay,
at 1:30. Would you accept that?
of course.
Oh, she gets
August 11th at
pissed.
1:30 in
Trust me.
Fairfield.
She
Mr.
gets
Cranny, anything
mad.
Additional?
I think this was noticed for a bond review as I read the minute order as well. And the bond currently looks like it's 125 cash only.
Yeah, I think he's already on bond in the other two cases, and he's on a PR bond. It's the 125 cash and 25 M5112. Are you very compliant to prosecution?
We are.
Okay. What is the request?
Well, Judge, obviously 125 is one that he can't make. He's been in custody now, it looks like going on 2 months. This is a class 1 misdemeanor. I read the affidavit. It's not extraordinary. It's a third-degree assault nonetheless. Because we can't get back into court for another 2 months, primarily because of my complicated calendar, nothing that he's done wrong or that this court has just imposed upon us. That means he'll be sitting in jail for quite a while on a class 1 misdemeanor. I'm going to ask that the court consider setting this a PR bond in this matter. I don't, and I apologize, I'm working off my phone. The iPad died here today. I don't know what his FTA is.
There are 6 failures to appear, unfortunately, at the end of December, all in the Loveland matters. And so last known FTA, it says April 3rd of 2025, which might be why the bond is set where it is. Prosecution.
We object to any modification of bond. When the bond was originally set here, it was with victim input that she believed a high cash bond was appropriate, that she had fears and requested a 100-yard no contact order. The people on that date requested a $3,500 cash or surety bond. The court issued, of course, the $125 cash bond. I disagree with Mr. Krenning a little bit in terms of the facts of this case. This does seem to be a little bit more than just your ordinary incident. There was some violence here with the defendant alleged to have grabbed the victim's head and smashed it into a bed frame. I'll also note that there is out-of-state history in Wyoming, specifically with prior assaultive behaviors. With respect to bond here today, we consulted the victim and she continues to object to any modification of bond.
I'm uncomfortable with the failures to appear. I do think that the affidavit that I reviewed does appear serious. This is a domestic violence enhancer. The court is considering the position of the victim. I'm not inclined to modify the bond. I can put Judge Lehman on notice that you may visit it again, but I want to make sure that you are in front of his courtroom to address these cases, and well, you will be there because you'll be in custody. And so unless you post the bond, but a PR bond is not appropriate in these circumstances. And I've set it in for August 11th. Certainly if there's a change in that, in the case, Mr. Cunning, maybe you can adjust with Judge Lehman. Okay,
Okay.
that will be the order of the court. Thank
All right.
you. Thank you.
Maybe.
Could be. Mr. Crennan will talk with you about that. Court will call Juan Martinez's matter 24 CR 1281. Yep, we can pass it. I thought I was making him wait. No problem. Mario Simpson, 24 M2529, 24 M254, 325 M921. Mr. Simpson is present before the court and he is out of
Don't.
custody. Ms. Lowry is present as counsel. Mr. Simpson, you do great with Logan, it sounds like.
So professional,
Doing a lot better
guys.
With pretrial services, so that was great. And so it looked like your report was pretty good, from what I could see, so well done. Do I need to, it looks like I need to issue in the 921 case a Bridges order, so we'll do that today. And I don't know if we've ordered the eval in that case or not, but I will make sure we do that in that case as well. Isaac, I'm reading the direct chat. I don't know if we have an evaluator assigned, but it looks like from what I'm being told, we might not have a report till August 11th, Ms. Lowry.
We saw that as well.
Okay, all right. I think I was aware that the district attorney wanted to address the mandatory restraining order. Is that right in the 25-921 case?
That's correct, Your Honor. We filed a motion there with two victim names. It looks like those were neglected when a bond was initially set, but I would ask that those orders issue.
Okay, and so let me just tell Mr. Simpson, I don't even know if you know these individuals, but you cannot harass, intimidate, molest, or alarm any victim or witness. That's what this is going to say, is we're adding 2 people to that order. And their names are Cassandra Thornhill and Michelle Conlon. And so they'll just be added on that. That's an order for everyone in all criminal cases everywhere. You know not to do that. So I will add them on there, grant the request. Other than that, Ms. Lowry, I think we just wanted to maybe just check in. He's doing great.
I agree.
Okay.
Just like to say, I actually wasn't planning on ever going back to that place. Ever again.
Okay, so that will make it, yes, so you're not sad. You're okay with this.
Yeah, it was my decision before I found out about any of this.
Okay. And I'm just, prosecution, you said that there's an order for me to sign.
Mini
in,
shorts.
Is it 921 case?
My shorts are like Daisy Duke.
Let me double check. I thought we
You very well may have.
filed request. This might be quite a, yeah, this was back on May 12th.
Okay. I said we would address it at the next appearance because I just wanted to make sure Mr. Simpson and his lawyer were here. We've addressed it. It'll go into place. Okay, of course. Okay, may we set this in just for check-in? Ms. Lowry, are you here on July the 10th?
Yes.
Okay, and can we set this in at 4?
So in this docket, we have a man that's kicked out of court and we have tears. This woman is just in tears. It's either, we're either going to see it today or Sunday morning. We'll see if we get to it today or Sunday morning. We might get to half of the swearing guy today because he starts swearing at her and she kicks him out. And then she brings him back in after he calms down.
30 in the afternoon on July 10th?
Yes.
Okay, yeah.
4:30 on July 10th. Correct.
All right, Mr. Simpson, keep up the good work.
Thanks.
You're welcome. You can get the information as that motion. Jamie Warner, 25 CR 5063 is present before the court in custody. Mr. Iddings is here as counsel for Mr. Warner. Hi, Mr. Warner. How are you today?
Well, how are you?
I'm doing well and well done.
I like your
Warner.
cartoons,
I know
sir.
that you got accepted to the work release program. Congratulations. That's a nice option for consideration. Though I do know that it's going to require a bond modification.
Oh, we had Simpson and now we have Warner. I wonder if they fight over which cartoon is better.
modification, but we'll visit that in a moment. Well done. When you met with Dr. Ziegler on June 6th, I know you have taken medication consistently 100% of the time the way that you had arranged with Dr. Ziegler. Feels from my perspective that you're taking your wellness very seriously. And I know folks are wanting to support you in finding housing. I know you're trying to get your finances and have access to your finances, and you've been trying to do that for a while. Mr. Iddings, your recommendation to this court?
Your Honor, we have an outpatient restoration plan. May I approach with that unless the court already has it?
I don't have it. You might approach with that. All right. I do have an outpatient plan. I'm going to review it with you, but I will need your signature on it, Mr. Warner. But I'm not, let me double check. Are we VRA compliant to address bond today?
We are.
Mr. Iddings, what is the, I know these are the conditions that would be in place, but what is the request for the bond modification?
Your Honor, we would be asking for PR bonds. I do believe he's gonna be able to access his finances quickly and easily once he's out of custody, so we wouldn't object to high PR bonds. So there would be added incentive for him to comply with work release and his restoration plan.
How, sir? Did you say those words slowly in your head before you said them out loud? How? How is a higher PR bond going to make any difference? When is the last time we saw anybody have to pay the amount that was on their PR bond when they didn't show up? Never. Never. No one ever has to pay them ever, ever. So if they don't show up, they do get, you know, a warrant. And then the judge usually puts a no bond on there, or they give them a bond at that time. But no one has ever once had to pay the price of their PR bond. So it's ridiculous that there's even money attached to a PR bond, because it means nothing.
So that's what we're asking for is just a PR bond in any cash amount that the court deems appropriate.
Prosecution, there's one case, right?
$5 million.
Prosecution, your position regarding that modification.
Thank you.
Yes.
I'm glad
So that's a bond that she paid and had to forfeit, or you paid, or someone else paid. This is a PR bond. So that he's getting out on his signature, and he has like a $5,000 PR bond or a $20 PR bond or whatever. It's still no money. No money changes hands. If he doesn't show up, technically they are supposed to charge him that amount of money. So if you don't show up, you owe us $5,000. They never, ever, 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 ever do that. Instead, if he doesn't show up, they put a warrant out for his arrest, and then they give him a bond like anybody else gets while they're in jail. So I don't know.
Mr. Warner has been accepted to the program. I think the program provides good oversight and support. And so I quite honestly would rather see him in that program than simply post a $500 cash bond and not have that support. There are multiple victims in this case. We notified all of them of the requests. No one expressed an objection. So I would concur with Mr. Iddings' request.
All right, Mr. Iddings, I'm sorry. I'm going to have you come forward, and if your client would sign the, that's okay. I don't know how easy it is to sign the plan when you have handcuffs on.
So you've gone over this.
Pabst Blue Ribbon. They do have that coffee beer that I didn't think I would like, and I just love it to death. PBR. Oh, you just gotta be law abiding. No, he's not gonna be. That's why he's here.
Right, thank you, Mr. Iddings. Mr. Warner, if I modify the bond, the conditions, and let me add one more, and that is if someone's in work release, we do monitor for sobriety. It's part of the work release program, so I'm actually going to be including that in this paperwork. That's the only modification that I'm making to it. But these are the conditions for you to stay at work release and be out of our jail. And if you're agreeable, then I just want to make sure if there's any concerns, I need to know, because otherwise you'll end up back in the jail, okay? So you're telling me that you're going to meet with Summit Stone Health Partners regularly to take the classes. They're twice a week, that you're going to keep in contact with Brandy at pretrial, and you're going to keep working with Kenny on this team. When it's time for another evaluation, that you'll cooperate to get the evaluation done. You're going to return the calls and emails from Kenny when he's trying to get a hold of you. You're on enhanced pretrial supervision. There will be substance monitoring, no alcohol, no drugs, no recreational marijuana, no contact with Eagle, I think it's Memphis Eagle, Francis Black Bear, and Robert Grant. You need to remain law abiding, and the mandatory protection order is in place, so don't harass, intimidate, molest, threaten any witnesses or victims of the case. You have a 50-yard distance restriction from these people that I listed.
She's still allowed to play dominoes, so she'll be fine. He's still allowed to play dominoes. He'll be fine.
So be aware of that. And you are to take prescription medication as prescribed by the doctor. And you are to stay at work release. You may not leave that program unless you have an order of the court. Are you agreeable to these requirements?
Yes, I am. I just wanted to make sure, because I thought that they said that they could take me somewhere if I had an appointment like to go to.
Yes. I just don't want you to leave without their authorization and decide you're going to go live someplace else. You need to stay there until it's modified in front of the court. Okay. At this time, the court is going to modify this bond to a $2,000 personal recognizance bond, adopting all the terms and conditions I just reviewed. We will make you a copy of this order, and then you will be transferred to the work release program Monday at 8 o'clock in the morning. You'll be releasable to our team to be moved over to work release. And then I'd like to revisit this council on July the 3rd.
I'm available.
At 3:30, sir.
That works.
If you need to be virtual from work release, you can. If you want to be here in person and that can be accommodated, I welcome you. I just want to check in and see how things are going on that day, okay?
Thank you.
All right, I feel like now you might be able to get this banking piece finally in order, and then we will be working with you on the housing as well. April?
Did she say spanking?
Releasable at 9 a.m., not 8.
Oh, sure. We'll release you at 9 so that people can sleep in that morning. All right, Mr. Iddings.
Your Honor, the one thing I wanted to be clear on, the no contact order is only with the individually named victims and not with the El Palomino Hotel. I have told him that, he should not go there, but with one of his caseworkers, if he'd be able to call them just to see if they still have his property and if they know where his property is.
Is it possible for our team to help facilitate to see if property is still at El Palomino? Is that something Kenny might be able to help with? Oh, there you are. Okay, thank you. Let's have you not doing anything with the El Palomino. I feel like maybe that's not one of the best places for you to be anyhow, and Kenny will see if he can get your property back. But let's transition to work release. Let's get your finances back in place. I feel like with what you described your financial situation is, you should have a really nice opportunity to find some better housing than being at the El Palomino Hotel. Okay. I'm excited to kind of see where this goes, and July 3rd at 3:30, it'll be nice to come back and kind of see if you were able to get that financial piece access to it. Mr. Iddings?
I don't have anything further this time.
And we'll just double check that El Palomino's not on they're not on there. They're not on the one that we just made a copy of. So I don't think that that's an issue, but maybe just like human to human, maybe just no El Palomino. Yeah.
And if it was $50 or something, it would be no big deal, but I have a ring that was there, and I have a 75-inch Sony TV that was in there that was.
Yeah, and we don't know if it's still.
I don't know what they did.
Contact.
Yeah, it might.
Okay.
Yeah, Kenny will call, but I don't know if they still have your stuff or not. And so let's see what happens. Hope that they do have it. But in general, I'd like to see a different plan than that because I think you will be more successful elsewhere, sir. Okay. All right. I'll see you on July 3rd.
Thank you.
Make that transition successful, please.
All right. Fun and relaxing or frustrating? Which do you think this is? All right. See this tube? In it are tiny little mini puzzle pieces. I am going to do a micro puzzle. Oh, I don't know if you can see it. And I'm wondering if, don't eat that. Sorry, I'm a mom. Every time I have a tiny little thing, I have to say, don't eat that. I'm wondering if that's going to be more frustrating or relaxing like a puzzle is supposed to be. Oh, I got tweezers.
Timmy Baines, 22 CR 590, 22 CR 1855 is present before the court and he's in custody, appearing from, I believe, the RISE program. Hey, Mr. Baines, how are you?
Hey, good afternoon, Your Honor. I'm taking it easy, can't complain.
Oh, nice. You look good.
You can
And
complain.
you're doing really well. In fact, you not only are doing really well, I know that what was reported to me is you've kind of discovered a really great balance with your medications while you've been there that you feel like is working really well for you. Is that accurate?
That is her number one thing. Medication. You are good with your medication. This judge will give you the entire world.
Yes, ma'am.
I'm happy for you because I know how successful you can be holding a job and, you know, all the things that you had when you were in Denver. I think medication is part of those pieces that for your wellness, you need to have a good, solid plan and consistently take it. So please make sure you take it each time. But overall, I thought you did a really, really nice job on this report. I'm really proud of you. Your attorney, Mr. Iddings, is in the courtroom. Let me give him a chance to make a record as well. Mr. Iddings?
And Mr. Baines, we haven't formally met yet, but Mr. Landers is moving to a different courtroom, so I'll be handling your case going forward.
Well, Mr. Iddings, you will like working with Mr. Baines. He's polite, he's kind. He used to have a consistent job and was quite successful for a while living in Denver at one of our homes that was available at the time. And he held his job for quite some time. We were very proud and still are. He's still maintaining a lot of hope and getting back on track. So I think you will enjoy working with Mr. Baines.
And I've heard many good things about you from Mr. Landers, Mr. Baines, so I'm looking forward to working with you.
Yeah, sure.
Okay, anything else from the people?
There you go.
All right. Mr. Baines, once you are restored to competency, they are going to send you right back to me. So I'm going to set this out a little ways. And if it happens sooner, I'll see you sooner than this. But let's set this out to the August 7th court appearance at 3 o'clock. And prosecution, if you could do a video writ for Rise for Us, please. It's my understanding that he's doing really well. I think he has a 6th evaluation in the works, and it's my understanding that it may be prudent and wise to set this for potential bond modification upon our return. So Mr. Oxmacher, if you could please.
One of them is a master, those,
That we're prepared
a
to
master.
respond when we come back. Okay, anything else, Mr. Iddings?
Not at this time.
Okay, great to see you, Mr. Baines. Keep up your good work. Keep up your good work, sir.
Keep up the good work. Take care.
Thanks, I will.
You're welcome.
All right.
And let me go ahead and call Kason Soderberg, 24.
This one looks like it's probably going to be boring. This one right here.
Before the court, and he is out of custody. Give me 1 second, Kason. I just need-
On his way back up.
Let me see if I can.
Video.
There we go. All right, thanks for your patience. And I have our attorney, Ms. Lowry, here in the courtroom. Mr. Soderberg is present on 24 CR 1248 in the virtual courtroom out of custody. And I believe that we got an evaluation back. And Ms. Lowry, is there any objection to the court adopting the findings?
Yes, Your Honor, I am asking for a second evaluation. Dr. Joshua.
I didn't expect that. I thought it would be boring. A second evaluation. Actually, Nan, none of my cats or my dog ever gets on my bed. It's because it's not my bed, it's their bed, and they get on that all the time.
Field has agreed to do the evaluation in person. That was our request, to do an in-person evaluation. Mr. Soderberg and his family would travel down the 3-hour trip from Wyoming to do that in person. And so I think Dr. Hatfield is needing about 7 weeks to complete that. And so it looks like I'd be asking for another date in August.
Okay, I understand. I will order the second evaluation. I'll sign for Joshua Hatfield to complete the second evaluation at state expense under the contracted rate. Mr. Kaysen, or I'm sorry, Mr. Soderberg, I know you're doing a good job checking in with pretrial, but I actually I just want you to actually connect with the case manager instead of just checking in. So Ms. Lowry has some information about how to do that and who to get a hold of.
So connect with the caseworker instead of just checking in. They time the call. So if you're on with your caseworker for 5 minutes, that means that you're just barely answering questions. If you're on for 3 hours, that means you are fully participating. I don't think he knows that they time his call. So he needs to make sure he puts the butt hours in when he makes these phone calls.
So she'll be in touch with you. Okay. Mr. Berkey, is this your case?
Yes, Your Honor.
Okay. Any additional record you'd like to make?
No, thank you. What's that date?
I haven't given one yet. Give me 1 moment. So you're saying it's going to take 7 weeks for us to get the evaluation back, Ms. Lowry?
That's right.
Okay, give me 1 moment. So that brings us to July the 31st. Mr. Berkey, what time that afternoon are you available?
Your Honor, I'm actually going to be handing this case off for the time being to Mr. Mangione, but it looks like he's available all afternoon that day.
Okay, then let's set this in 4 o'clock on July 31st, and the court gives permission to Mr. Soderberg to appear virtually, given where he lives, and that's a far drive. And anything else, Ms. Lowry?
No, thank you. I have the contact information, and Kaysen, I'll be in touch with you and your mom about the request by the order by the judge about regarding.
Okay, thank you.
All right, you're welcome. Take good care.
Very well.
Eric Downey, 25 CR 5014 is present before the court. He's in custody. Mr. Iddings is present as his counsel.
He needs a doctor.
Right. Hi, Mr. Downey.
Do you want some?
Let's see.
Do you want some cats? I think you want some cats. Do you want some cats, Scott? Hi, Terry. You can have some. How about 5? Do you want 5 cats? Please? Please?
You've been recommended to go to the RISE program. I don't know if you heard me just speaking to Mr. Baines. He's at the RISE program and is doing quite well. And so that's a nice alternative. Not everyone's eligible for that for the restoration work, but you are. And Isaac, who you can't see, but he's online, he's the navigator and has made that referral for you. That should make this process faster and keep you out of the state hospital in Pueblo. So that's all really nice news for you. And I think that probably a lot of that has also been facilitated by your choice to take medication consistently 100% of the time. And so you seem like you're taking your wellness very seriously and they are willing to look at you for that program. So that is wonderful news. So let's see, I think once you go to RISE, I do want to make sure, Kenny will be in touch with you as well. So he'll still stay on your case.
So RISE is absolutely excellent. Excellent. It has a hugely high success rate. And it's not just for mental health. The RISE program is not just for mental health. It's for addiction, people with anger issues. They get treatment. They get real treatment. People actually, figure out what they need and put them in the correct places with the correct counselor, therapist, medication, housing, what they need to get back on track. It is, I think, a program that the rest of the states will probably follow at some point because it's just doing so well. I wonder who designed it. I don't know.
Helping you as well.
I
Okay.
really appreciate everything. Thank you.
Welcome, Mr. Iddings.
He is doing much better, not only from the consistent medication, but he's been sleeping really well. And I think that's a big part of his wellness, just because when he was living on the street, he was not consistently getting a good night's sleep. And that can make all the difference sometimes.
It makes a
But,
ton
he
of
is doing
difference.
a lot better.
Wonderful. That makes a huge difference. Mr. Oxmarker?
I'm nothing bad. Thank you.
Okay. All right. And so
Okay, it is definitely way better than I even thought it was, guys. The RISE Colorado program was co-founded in 2012 by 3 Latinas, according to their website. All women of color, teachers, and organizers aim to address educational, wait, this is the same. No, this is definitely the program. It's jail-based company restoration program in Colorado. That's not it. Another program also uses the name RISE, and that's not what I'm talking about. But it's just 10 years. Wow. It's just such a good program. Kudos to those 3 women.
I just put in the chat wondering if Isaac has any idea when there might be a transfer to RISE. I think no specific date is known. That's okay. Just thought I would check. What I'll do is I'll set this out to August the 21st. We'll set this at 3 o'clock. We may need a writ from RISE, Mr. Oxmacher. I anticipate he'll be moved earlier than that. And I will tell you, Mr. Downey, when you go to RISE, and it does seem like you're doing so much better. If you go to RISE and they feel like you're ready to come back to Fort Collins and you're able to stand those criminal cases. And
I think I have 13 members on my multiple level membership. And Crystal, you're one of them. And I thank you. I really appreciate you. Thank you so much.
defend yourself, they'll send you back anytime, even if it's before the next court date. And then we'll add you and immediately bring you back to court. So August 21st is the latest date. I will check in with you. I might see you sooner than that, okay?
Okay.
Do you have any questions?
Oh, no, this has been very easy on me. Thank you.
Okay, keep up your good work. I'm glad you're taking the medicine and you're sleeping better.
Yes, I'm taking what they're doing.
Good, you're doing well. Well done, thank you. Thank you, Mr. Innings.
And what time on the 21st again?
You know, my short-term memory, 3 o'clock.
All right.
Okay.
I don't have short-term memory
All right,
problems.
Thank you.
I also don't suffer from short-term memory problems.
And let's have Peyton Yeager, 25 CR 5001. Present before the court. He's out of custody. Ms. Lowry is present as counsel. Hi, Mr. Yeager. How are you today?
I'm good, how are you?
My sir, sorry.
Really nice. I got your evaluation back, and so let me check in with Ms. Lowry. Is there any objection?
No, Your Honor, I'm prepared for the court to accept the finding that he's competent to proceed.
Okay. I'm
Okay.
gonna adopt the finding.
We finally got one who's competent now. So he has been restored. So now, unfortunately, now he has to face the charges that got him locked up to begin with. A lot of the times, because of the amount of time he spent in custody or in programs, just becoming competent again, the other cases dismissed or time served and things like that. So depending on what he did.
That you are competent to proceed. So I always am going to be honest and transparent with you. You have a UA that came back. It had marijuana and alcohol in it. Nothing is happening to you today. You're not going to jail or anything like that. But you need to be really careful because your bond conditions don't allow for you to have those things in your body. And you need to keep doing your tests. If you need more support, because sometimes people do, there's nothing wrong with that. Just let Ms. Lowry know or let pretrial know. But just make sure that if it's just something that you're doing socially or recreationally, that needs to be kind of cut out so that you can stay in the community on your bond. Otherwise, they might file an affidavit and Ms. Lowry can explain more about that to you. So make sure everything is kind of cleaned up. That way you'll be hopefully successful to stay in the community until the next return date.
No,
Ms.
it's
Lowry,
not.
I
Extreme
have
is. You are an
that
extreme,
visiting
Fozzie.
to Judge Villasenor on June
Thank you very much.
26th. He has 10 or 10:30 available. Is one better for you?
Can we do 10:30?
Yes, we can. As long as your lawyer's okay with that. What's that?
Can I add something?
Yes.
I've been working with my probation officer to get my med card. Like I have it right now, but I'm trying to send it over to her.
Yeah, so once you have a card, just like any other prescription, you would give that to pretrial services. And then they would see that you do have a prescription and that the amount in your system is consistent with what has been prescribed. However, I'm not familiar with anyone having a prescription for alcohol. So please make sure that things that are going
Someday
into
we
your
will,
body
though.
is things that belong there. And if you
I feel like now I have to become a doctor so that I can prescribe alcohol. I feel like this is my life's work. This is what I've been chosen to do. I've been training for it my whole life. I actually started my doctrine, not a medical doctrine. I started my doctrine. I wonder if a doctor of computer security can prescribe alcohol. I wonder if that'll work. Okay, new life plan. Make it possible for a doctrine in computer and IT and anything like that. A doctorate. Doctrine. I have a doctrine. I don't. A doctorate can prescribe alcohol because it's not really medicine. So I'm not prescribing medicine.
Do you get the medicinal marijuana card? Just give a copy to pretrial, okay? All right. And so, Ms. Lowry, did that 10:30 work for you?
Yeah, that's fine. And we already have an agreement actually with the district attorney in that
Okay.
division, so we'll be able to enter a disposition. So we could set it for disposition,
Well,
please. And then I just wanted to say that Kenny really helped my client and his family get hooked up with Foothills Gateway here in
great.
and so that's all going well, and I appreciate those efforts.
Yeah, I really like that. Have you've been working with Foothills?
Oh, yeah, I just, you went down last week, I think.
Yeah, they're great. I used to really enjoy working with them before I was a judge. Now I get to see them in court. They do a really nice job, and you'll be very empowered to make decisions. Foothills Gateway will honor your ability and desires. And so make sure that you stay in contact with them. I would maybe ask Foothills too. I mean, if I don't know what the prescription is for marijuana, but maybe there are other things that would be
Tomato.
better for you, so that you'll be clear-minded, because sometimes there's opportunities for you through Foothills Gateway. Sometimes people even have job opportunities. Sometimes people have activities they want to be involved in. And so I want to see you in the healthiest place possible, if you want to participate in those things, okay? All right, so Judge Villasenor, next door in courtroom 3B, June 26th at 10:30 for disposition.
Thank you very much.
Thank you.
Hey, thanks for the comments on the videos.
It's 3:31.
Hello.
As soon as you're ready, Mr. Leclerc, let me know. No problem. Counsel, and if our Pashto interpreter could please enter your appearance.
Pashto interpreter.
Thank you for being here. Yeah.
Pashto.
I didn't see you in court yesterday. Oh. Okay. You were here yesterday? I thought I saw you with hat on back there. Okay. All right. Did you just think court was yesterday?
Anybody know what Pashto, where that's from?
We came to see someone, but I couldn't find them. But yes, I was here yesterday.
I thought I saw you. You're doing a good job. You went to pretrial services. It seems things are well organized with pretrial.
It does sound like that.
You're connected with some.
Very cool. Very, very cool.
Getting on track with them. This report is so much better than the one that we had.
Nice.
That's because you have done a really good job of getting everything together, and I appreciate it.
Thank you.
Ms. Lowry, I brought this in just to check in and make sure that Mr. Syed was on track, and he is. I can set this into August for him. Your thoughts?
That would be great. I'd appreciate it.
Prosecution?
I was very pleased with the report. I think August sounds good.
And one more thing, Ms. Lowry, I don't know the newest case. I don't know all the circumstances. I know it's not with his wife.
آخری کسی وای سیاخیستی و عقب پیگمز دی خزی سری مشکل نو.
I can't help but wonder and worry if some of the cultural differences may be increasing his contact with law enforcement.
والفكر كوم ده چون ده بلک کلچر نراغله ده یعنی امکان داری سی دقیقه بعض مشکلات هم سی ورته مخترزی دیگه اغی اثراتی.
I don't know what can be done to provide additional support around that.
وای نه پیگمز یعنی مختر خم کمک کولی سوسی به ده موضوع کیوکو.
I feel like that might have something to do that's complicating the circumstances.
اما قدر سی وای تاس زده سی مشکلات مثلا مختکیگی و مختسوی دی.
Whatever Logan can do, or if you're aware of any resources to support him, that would be great.
و یا تاسو د وکیل ته دی وایس یا تاسو یا لوګن ارڅو مثلا ارڅو مر کومک سره دوی سره کولای سي وکي.
August 7th, 4 o'clock.
I wonder what that means. I need more information. Cultural differences are getting him in trouble with the law, but I think she said this has nothing to do with his wife. I need more information, Judge. Judge, please.
Will return to court for your cases for review.
دی آگست بوم تاریخ به سلور بجای در تکی خود درست اورورا. Thank you, Judge.
All right, wonderful. Thank you. Have a great day.
و یباز دی بخیر خدای پامان رورا. Thank you, Judge. Have a great day.
Thank you so much.
Thank you. I'm going to call the matters of Bradley Gildea, 25 CR 301.
I think it's showtime, guys. I think.
He's present before the court. He's in custody. Mr. Leclerc is present as his counsel. Good afternoon, gentlemen. All right, Mr. Gildea, I have been sitting up here for a long time, and I am older than you, and I'm going to give you some advice. Our team wants to help you to see if there are alternative places for you outside of the jail. But one thing I know for certain that people are going to want to know is if you are stabilized on medication and how you are doing while you're in the jail. When you come to court and you're in orange, I know that you are behaving well while you're in the jail, so that part looks really good. But when I read this report and some of your medicines, none of them you're taking more than 44% of the time, that could be a barrier when people are looking at potentially having
Judge
you
doesn't
in
like
their
that.
programs. And people are interested in having you in their programs. I don't know if you're aware of that, but it's really hard when Emily is trying to find a place for you if you're not kind of working compliantly with the things that you've agreed with Dr. Ziegler for your wellness, for your medicine. So you need to take it each time it comes to you. Do you understand? Okay, because that's part of what's going to help them find an alternative so that hopefully you don't have to stay in jail. Where are you from originally? Okay, and so I don't know if you have family there still.
My grandma.
Okay, so maybe at some point, maybe that's an option, but we need some steady, some good, track record. Otherwise, I know Monarch has been referred, Fidelity has been referred. The Valor program said that they can't take you this time, but maybe that would look different if you were taking the medicine more consistently. So that's my what I was going to say to you, Mr. Leclerc.
Yes, Your Honor. I know I've spoken with Bradley too about taking medications, and that's how we can facilitate getting him out of custody. I would know for the court, we're still pending the competency evaluation. I don't have any information. I know on the last letter that was filed, we were supposed to have it today, but I don't have a status update. So I know we're very anxious for that because I also know some of these programs require that evaluation to get him into participation.
I did not see a report come through, but I'm going to ask Isaac if there is a The report did not come back, but it looks like Isaac said he received it yesterday and it's suggesting tier 2. Do you have an objection to me adopting that, at least for the moment, to get him qualifying for some of these opportunities? I haven't seen the report. You haven't seen it.
I have not, Your Honor. I think really the question here is, what's he going to be tier 1 or tier 2? So I'm assuming that the report is that he's not competent to proceed. We have no objection to that.
Any objection?
Your Honor, I'm wondering if Isaac could email it to me real quick, just so I could take a very quick gander.
Okay, Isaac, can you email that to Mr. Oxmacher? Yes. Let me pass this case for a moment, Mr. Galdea. I'm going to pass your case for a moment so that maybe Mr. Leclerc, if you can forward that, Mr. Oxmacher, to Mr. Leclerc, he could take a peek too.
I'll just sit next to him.
Okay, you'll just sit next to him. Everyone's friends now. All right, Yvette Muniz, 24 CR 433, 25 CR 589. Maybe we don't have Ms. Muniz in it yet. Are you taking this case over? Oh, we do have her. Okay. Oh, she's here. Mr. Landers is here too. I don't know why you both are hiding in the back, but come on up. 24 CR 433, 25 CR 5.
It's fine, Kelly. Thank you.
Landers is present as her counsel, and she's here in the courtroom. Nice to see you. You look nice today.
Yeah, I deleted one of his comments in Discord, so he's unhappy.
How are things going?
Little rough,
A little rough today?
Things, yeah.
Okay, well, I hear that, you know,
They are going to kill me.
Ooh.
These cops are going to kill me. Please let me go.
All right.
Please.
So I don't have you in custody. You are out of custody. Well, you have charges pending. Your lawyer will talk to you more about that. Let's have her connect with Brandy and get back on track. I liked that you are asking for more mental health treatment support. I think that's great. And I know that you're working really well with, I think, North Range. Is that right, Mr. Landers?
She is definitely reaching out, trying to get help.
Okay.
She understands kind of the depth of some of the issues that are going on, and
Okay.
we're welcoming any mental help that she can get. So
I think that you're very stressed out. I can see it. And so I don't want to keep you in the courtroom.
That's because the cops knocked my teeth out.
Okay. I don't know anything about that. I'm
I
sorry.
need to know what's going on.
she's referencing her most recent case involved an altercation with the police, and she's charged. Unfortunately, she suffered some injuries.
Okay, I'm sorry. I can see this is hard. I can see you're emotional. I understand. I'm sorry. I can't, and Mr. Landers can tell you, I can't just dismiss your case. And so I'm always going to be honest with you. That's not something I have the authority to do. But I hope not. I hope you're going to be okay. Mr. Landers, if she doesn't schedule the restoration, it's going to close. So are you aware of that?
I am. They actually put a pause on that due to
Okay.
wanting to stabilize the mental health things, and then she didn't have a phone, but Emily's working with
Yeah.
her on that front.
Okay. Can we just check in July the 10th at 3:30, Mr. Landers?
Would it be possible to go out 1 week longer, Your Honor? I'll be returning.
We don't have a docket on the 17th. I do have Magistrate Clark here on the 24th if you prefer.
That would be my preference.
Okay, let me set this in then at 3:30 on the 24th of July. Just to check in. And you're connected with Mr. Landers. He is your advocate. You have a private relationship. You can talk to him about anything and everything. He will help you. I'm sorry, but I'm going to let you just kind of be able to go process everything for a moment with him and get you out of here today, okay? Hang in there, Ms. Muniz.
Thank you.
Thank you.
I would like that body cam. Sounds like she might have resisted a little bit.
Yeah, we can recall Mr. Gildea if you like.
Court will call the matters of Bradley Gildea back in front of this court. Those matters are 25M233, 250233, 250301. You all had a chance to look at it?
Yes, Your Honor.
Okay. Your position remains the same?
It does.
Mr. Oxmacher?
I've reviewed the report. It indicates that he is not competent, but is likely to be restored. It recommends tier 2. I have no objection to the court.
And I will adopt exactly those findings and order inpatient restoration at this time at a tier 2 level. Mr. Gildea, work with Emily. Let's see if we can come up with an alternative plan. Please consider the advice I've given you with regards to your medication. It sounds like Mr. Leclerc is giving you similar advice as well. Let's see if we can develop a plan and see what we can do to help you. Mr. Leclerc, I know it's a long shot, but are you available the afternoon of July 3rd, sir?
I can be, Your Honor.
Let's set it at 3 o'clock for potential bond review if there is a proper plan that the court can consider. So work with Emily. Let's see that medication consistent, please. So I'm going to visit your bond with you when we come back, but what I'm listening for is a plan for stabilization. So I want to see how you do between now and July 3rd. Let's write a great report, Mr. Gildea. Let's see what you can do. Hopefully one of these places may be a good option, okay? See you then, sir. I can call non-VRA 4 o'clock matters early. Do I have Patrick Erickson available early? Okay. Okay. Do I have what about Ms. Kewen? Is she available early? I think she's not a VRA case. Not yet. And I think those are my only options. So we'll just hang tight till our next in custody matter is brought upstairs.
I think the next, we got through the crying. We didn't get to the swearing though. And we only have a few minutes left. So it has to be soon. Let's see, this might be it.
Ms. Clary, who should I call next?
Nicholas Hauk, please.
We'll call Nicholas Hauk, 24 CR 1815. He's present before the court in custody with Ms. Lowry present as his counsel. Right. Hi, Mr. Hauk. How are you today?
Okay.
I know that you have been accepted to Fidelity, though I'm not sure what will happen today, but I am happy that you are taking medication 100% of the time, one of your medicines, the other one majority of the time. Please take it every time it comes out. I think that probably was one of the reasons Fidelity was willing to work with you, is because you're showing consistency with your medication, your dedication to your wellness. And so that probably helped you. And so be thoughtful about that. Ms. Lowry, we are on notice, I think, for bond review. Are you VRA compliant, Mr. Oxmacher?
We are, Judge.
Okay, this is a very high bond. $100,000 cash or surety. Would you all give me just one moment to read the affidavit?
Whoa, what did he do?
Everyone.
I don't even see murderers with $100,000 bond. I miss Judge McConaughey all of a sudden. Is he still around? Is Vance? Is it Vance? Stephen and oh gosh, who's that public defender that we love to hate? Oh gosh, in McConaughey's courtroom. Vincent and come on, y'all know who I'm talking about. What is his name? How could I forget his name? Getting old sucks. I cannot remember his name. And as soon as I say it, you guys are going to know exactly who I'm talking about.
Bond application for a moment.
I think he has like a Jersey accent or New York, maybe.
No. Expired at the end of the year.
Thank you for letting me know. I'm sure I've asked you that before. Thank you. Are the cases in Denver cleared up at this point?
He is only being held on this case, so yes.
Ms. Lowry, what is the request?
Your Honor, I'm asking the court to set a personal recognizance bond and approve the outpatient plan. I could approve those to the court.
Thank you. Thank you. Sorry. Thanks.
Mr. Houck has been in custody since November 27th, so over 6.5 months on these charges. That parole hold expired at the end of the year. So he's been in jail, obviously, for a considerable amount of time. He's in general population. He has no security classifications. He's in the mental health pod. He's housed in an 8-man dorm. So he's housed with the vulnerable population at the jail. And so the jail obviously has no real concerns about any kind of aggressive or violent behavior. As you've noted, he's been accepted to Fidelity. They're certainly aware of his criminal history, his pending charges, and they believe he's appropriate for their program and to be housed with other vulnerable folks that are in their care. I'm really just confused by the bond a little bit. This is an assault in the second degree. We have a lot of clients in this division charged and released on similar charges. I don't want to sound as though I'm minimizing the nature of the allegations. But I just wanted to point out that the affidavit suggests that Mr. Houck, whom police thought was experiencing some pretty significant mental health symptoms at the time, felt that he was in danger. That may not have been rational, but he had felt threatened by the named victim in the case. Thankfully, he did not suffer, the named victim did not suffer serious bodily injury, and the dangerous instrument or deadly weapon that was charged was the use of a water bottle that Mr. Houck was accused of throwing. We're not talking about a gun or a knife, and gratefully, we're not talking about serious bodily injury. I'm just unclear for why the bond was set so high at the outset, other than perhaps the parole hold and perhaps that Mr. Houck was not cooperative with pretrial when he met with them. And
To know what Magistrate Sage was thinking, but yeah, there was a parole hold. That's always a concern for a judicial officer. 2 warrants out of Denver is a concern. The charges are a concern. It looked like a random act of violence, though I agree it looks like it's mental health stemming. And so I don't know, but that may also contributed to where it landed.
of course. But I guess that being said,
Come on, guys. You know this guy. I'm just posting the link because I'm about to play this short to see if you guys know this guy. We love to hate this guy. And you guys, I can't remember his name. I know this is Vincent or Stephen Vincent. Hold on.
So I'm asking for a reduction, Judge, to
I can't read that.
personal bond for Miss Ashley, so she can get out, deal with the issues that she has to deal with, Judge, and you know, come to court and take care of these misdemeanors. These are Judge Bryant's cases.
She said, he's like, let her go so she can come back. The last time they let her go, she didn't come back.
Yeah, but here's the thing. Her bail is $100. He said,
and he's trying to get it lowered.
Lowered. He said lowered to nothing. See, that's a lawyer fighting for you right there.
Listen.
What's his name?
The DA is going to try to make it big, and he's going to try to make it as small as possible.
Yeah.
But Judge Bryant is not. It's not going to work. It's not with Judge Bryant. Not with Judge Bryant.
What had happened was.
What had happened was, I like that channel. I'm entertained. No, never mind.
Said we do have a lot of clients in this docket who have faced similar charges, influenced by similar mental health symptoms, who once stabilized in the jail, and he's had 6.5 months to do so. The medication that you referred to, he missed medication one night. He was waiting to see if he could talk to Dr. Ziegler, whom we've worked with even on the outside, but he's not refusing medications. He's completely committed to taking medications. He's still hoping to talk with his provider. If he can, and I guess he saw Dr. Ziegler today. So I did want to point one other thing out. He does have a twin brother who's quite successful in the community, lives in Aurora. Could be good support for Mr. Houck as he's working through a program. He said that it's been a long time since he's been offered an opportunity such as this one, where his mental health will be addressed, where he can get back on his Social Security disability, Medicaid, and to start looking to see how he can maintain the stability he's found in custody, in the mental health pod, in a program such as Fidelity. I'm hoping that the court will think that a PR bond, perhaps in a very high amount, as
he
an
is chief
incentive,
judge,
Mr. Houck, to comply with the enhanced pretrial supervision that's been requested, and as well with whatever rules that Fidelity has. I believe they'd be ready to accept him. Come up here tomorrow morning. If he were released at 9 a.m. To Morgan, she would then, but Fidelity will be, their representative plans to be in the lobby of the jail as well, to transport him directly back down there. And with as much check-in as the court thinks is appropriate.
Philip Reagan, man, you got it. It's Philip Reagan. Yes. You guys don't remember Philip Reagan? He is so annoying and hardworking and passionate about all of his, defending all of his people, his clients, and their murderers and their drug dealers and their gang members and their monsters, and they do bad things to women and children, and we hate it because he's so good at defending them, and he's so annoying, and he's elite at his job. And then we have Vincent, the prosecutor, and he's equal. He's an equal match to Reagan, and they're in front of McConaughey, and McConaughey, I mean, Reagan is such a good lawyer, but McConaughey is really, really, really a good judge. So he can see through a lot of it, but a lot of it, Reagan wins. And, you know, I don't know. Reagan is able to get a bond lowered, even if you do horrible crimes. Reagan is able to get your bond. If I was ever locked up, he is the one person that I would just really want, even though I'm in Pennsylvania and he's in Michigan. But McConaughey is so good. He like he verbally slaps Reagan down a lot. Oh, so yeah. So I guess the fact that he choked her until she peed all over herself means very little to nothing. She must just have a medical issue. Yeah, no, bond stays the same. I need to go get McConaughey. I need to go get some of his maybe for tomorrow because he's just so good. All right, I'm just going to finish this guy up we're not going to see the poor Judge Blanco get cursed at today. Anyway, I'll find something, Nan. Even if I have to go back in time, I will.
I believe there are many reasons why the bond was set as high as it was in this case. We've already discussed his criminal history, the fact that he was on parole. when
Oh, I
this
know where to
happened, the
find
fact that
him,
he had active
CJ. I just
warrants,
couldn't remember Phil's name.
But also,
The name.
assault in
That's
this
all I
case,
needed.
Was serious. It was unprovoked. It was prolonged, and the victim in this case is essentially just cowering, curled on the ground as Mr. Hoke continues to kick and stomp the victim.
Oh, this case, guys. Thank goodness the judge is about to watch a video, and thank goodness we don't have to watch it.
Court is considering modifying the bond. The assault was caught on video, and I would be happy to share that with the court before the court makes a decision.
What was he in prison for, Mr. Oxmacher?
Your Honor, it was, I believe, a menacing, hang on, I have it right here.
Trespassing to a dwelling?
So it was a Mesa County case, 19 CR 360, aggravated robbery, and a felony menacing charge was dismissed. Also concurrent was a 2018 CR 2461 Mesa County case, which was a first-degree criminal trespass.
Okay. All right, I'm going to reserve ruling on the bond.
All right, she's about to watch this video and react to it, and we're going to watch her react. But this is, who is this? Who is this person sitting in Mechanico's seat? That can't be Mechanico. Okay, it just can't be. I don't even know who this person is. I want to hear him speak, so I know. I don't know who this is.
Yes, sir, I understand.
Oh, it is him.
All right, that
Oh.
concludes the hearing. Actually, let me give you your next date.
Look how different he looks. Where did he get all that hair from?
Next date is,
No, that's not him. Listen to the voice.
June 2nd, 2025, before Judge Taylor. June 2nd, before Judge Taylor.
Who is this guy?
Bond is currently set at 10,000. Strike that. Bond's currently set at 100,000 cash or surety. I'm going to amend the bond to 150,000, 10% with GPS tether house arrest. If your client can make that, no weapons and can't leave the house at this point.
I don't know.
Your Honor, would you consider that tether
I don't
unit?
think
Because if
that's
he's gonna be on a tether, he's not gonna get out until next week. He does work, he's working with.
Was on, out on bond?
That's not him.
I am not
That's not Judge
aware
Mechanico.
of.
I don't know who's in his seat, but. Oh, no. Oh, that's all right. That's okay. That's fine. I think I have some Mechanico in my stream. In my old streams. I will look. I mean, oh no. I got a copyright strike. What in the world? None of these are my videos. I just got a copyright strike, and this is what it takes me to. What in the world? I don't even know what my video Merry Christmas is. What did I do? Oh, this son of a gun. Son of a gun. all these people showed that same bad driving video that I showed. It's okay. I mean, it's not bad. It's not like I'm in trouble, but I don't, whatever. Okay, we're gonna see her watch this horrible video, and then we're gonna go to OJ.
Sounds like you want to provide the court a video. Did the victim take a position as to this bond?
The victim did not. And Your Honor, I have the video up and ready to go. It would, probably take 3 or 4 minutes to review it.
Okay. I have other people waiting in custody to come upstairs. I think I have Mr. Komlowski waiting to come upstairs. And I have other folks on the docket for this afternoon. And I don't really want to air that as a shared item on the screens because it sounds like it's violent and there's no need for everybody to watch that. Do you have it on your laptop?
I do. I can bring it up.
Okay. All right. I'll take 3 minutes to watch the video. If you want to cue it up, go ahead and have a seat.
Now the video is 3 minutes long, and I think I fast forwarded it 30 seconds.
Thank you. All right. I did not watch
No,
the whole
I don't.
video. I watched enough of the video.
She couldn't watch the whole video.
That's very hard to watch.
I mean, all she said is that's very hard to watch, but doesn't that feel like a big, huge stone just fell on you? That is very hard to watch.
The court is not going to modify this to a PR bond. I understand that maybe $100,000 seems like it is too much for the bond in this case, but equally a PR bond seems way too light for what is a community safety concern for this court. Though I understand that there are times we do modify, it is always case by case. And if he were to leave Fidelity or stop taking medication while at Fidelity, the risk to the community is too great for the court to have a PR bond in place here. I could consider modification of the amount. I'm not sure if that will make a difference, Ms. Lowry.
We would take any modification the court's willing to consider. I would be remiss if I didn't share that Mr. Hauk believes that doesn't capture the full extent of the interaction with this individual who had been threatening to him before.
I just will say it did not look like a self-defense issue to me. The victim is on the ground with hands like this, trying to show that they're not doing anything. And repeatedly your client is assaulting the victim from the video that I watched. I cannot think of a circumstance of what would give context to that to make that okay, period.
I guess the last thing I would say about it is that I did review the full reports. I know that the victim did not suffer serious bodily injury. Gratefully, it was considered bodily injury.
Yeah, thank goodness. I am going to modify this bond in the amount of $8,000 cash only. Same terms and conditions. I've kept this as an in custody restoration. I'm concerned when I review criminal history as well. I know in this case, mental health may have had something to do with it, but unfortunately there are other cases in his history I don't know what the circumstances back then are, but you do have violent tendencies, whether it's when you're not medicated or in general, they're concerning for the safety of the community. And at some point, if these things are mental health related, you have a responsibility to take care of your wellness if that's what it looks like when you're not well. And after 2 stints in prison and everything I'm seeing, I would highly encourage you to kind of figure out how do you maintain that kind of wellness. Otherwise, you will be on a long track record of coming back to court and exposing yourself to potential prison sentences. I will reset this matter. It's going to be a time before inpatient is available, Ms. Lowry, as we both know. August 21st at 1:30.
Okay, we didn't make it to the guy who curses her out. We'll do that tomorrow. I don't have a second channel. I'm just putting every ounce I have into this channel right now. And if this channel gets shut down again, then that's when I say, okay, I tried and YouTube's not for me. Because I have tried. I am trying my hardest. Yeah, no, I'm not gonna. So I'll just be very careful. No one else is playing this judge. No one. Go look, search anywhere on the internet you want to search, and no one else has what I just played. No one, not any other channel on YouTube or anywhere else, or any other website for that matter. So if I stick with that, I am golden. If I don't play, inappropriate material like fighting and tasing and, things like that, I'm golden. I know in December, I just got that copyright strike because in December I played that video that, I thought I got it from a news station. I thought that was fine. If I don't do that, which I don't have to, I can get my own stuff. I do not need to replay something the news had. So I will be fine. I think. I hope. All right. See some of you in OJ. The rest of you I'll see again really, really soon. Thank you so much for coming out today. I really appreciate it. I hope you guys have a great day. Bye.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh